So good morning, everyone. Welcome to the second last session of this year's ELA conference. It's my absolute pleasure to welcome you all, not only on behalf of myself and my co-pilot this morning, Tendai Bonga, all the way from Cape Town. You see Tendai's face there on the screen as well, but also on behalf of the ELA. So we are grateful that you have sacrificed the rugby. Apparently there are some people watching rugby to be with us. And we are especially grateful to have two speakers who need very little introduction this morning. First up, we have Amanda van Reenen. Amanda is from the Department, Forestry, Fisheries and the Environment. She's a friend of the ELA for many, many years, in the sense that she's an incredibly valuable source of information, and the presentations are always very enlightening and informative. Amanda, good morning. And just before you start, I would also like to introduce Willemien. Willemien also probably needs no introduction at all. She's one of the main conference organizers, also has been that for many years. The secretary of the ELA. Willemien is also, we're not working very hard for the ELA, a professor of law at the Northwest University, and by many regarded as the mother of environmental law and from an academic perspective. So Amanda, Willemien, we look forward to your presentations. I will not be doing the Q&A. Tendai will take charge of facilitating the Q&A, to which we invite all the participants to engage with and to participate in. The session ends at 11. We are at 10:30, apologies. So we will have time for discussion after the two presentations. So Amanda, you are welcome to share your screen if you do have a presentation. And after yours, we'll have Willemien, and then we'll go into Q&A to be facilitated by Tendai. Thank you.
Thank you very much, Anél. Let me just get my sequence here. Starting my video, sharing my screen. All right, and slideshow. Can you just confirm if you can see?
Yes, we can see it. You can just put it in presenter mode at the bottom, Amanda.
I'm trying to, there you go.
There, yes, perfect.
Perfect. Alrighty. Thanks very much for that introduction, and thank you very much for once again hosting this incredibly informative conference. I know this is difficult under the circumstances, but the ELA has always been one of those aspects in conferences and events that we look forward to, and maybe next year we can do a physical one again. I'm hoping those who watch the rugby are not going to be telling us that we've lost, because then we have at least spent our time well in this conference. But thank you very much also to Peter and to Willemien for asking me to do this presentation. I did something similar to the Impact Assessment Association presentation conference, virtual conference in August. And I adapted it a little bit, but what was very interesting is that I didn't realize until Peter told me the title of the conference that we're actually celebrating a big milestone, 25 years into the environmental right, the new constitution. And then I'm very privileged to be asked to speak about how we give effect to the Section 24 right, and specifically how we link EIA, which is the field that I specialize in the department, the law and the environmental right. So without any further ado, 25 years is actually a long time, but it had gone past quite quickly. We all know all the rights that have been contained in the Constitution, the big, huge process and achievement that the Constitution and all of those human rights were when we got it all together 25 years ago. And from a departmental perspective, we obviously also take our cue from the National Development Plan when we try and look at can we achieve sustainable development? How do we ensure that the environmental right is given effect to, but also how do we ensure that development doesn't stand still and we don't hamper it? So we've also seen the IAIA conference focusing on sustainable development goals. It's, I think, quite an achievement to have some recognized SDGs and the concept of sustainable development. And I'm toying with some ideas that Willemien actually planted in my head probably unknown to her, to do an LLM around this kind of topic in the next 2 years, but that's for another day. The big issue, of course, is that sustainable development is all about, are we satisfying human needs? And only when you can argue that that is the case, that you can provide for your own generation and for future generations, then at least you can say it is a sustainable development, and therefore the environment could be protected under certain circumstances as long as the human needs are focused on and protected. And of course, the question is, have we achieved, what have we achieved since 1996? A big milestone, as you know. But I'm not sure if you can remember or who would have been involved in this. What I thought of immediately when I had to do my preparation for both conferences was a specific case that blew up in the media quite badly, but turned out quite well from an environmental perspective. Sorry. And this was one of the headlines that we saw in the media at the time. This was the first time an African government had intervened to save an endangered invertebrate species from extinction. And that African government was the South African government. And it was about the Brenton blue butterfly, of course. And I know we're talking about what has happened in 25 years, but this happened in 97 under the Environment Conservation Act. So the question was, is the law powerful? I suspect it is. What have we achieved since 96? I think 97 was a very good case in point, but that's not where we're going to stand still. The legislation, of course, and the environmental right, we have to ask ourselves the question, and you know, people want to be in the position where they say they make a difference every day, but does the law give effect to that environmental right? And I think that's precisely what we need to talk about. Are we painting the full picture? Sustainable development, as I've said, is it's a very human-focused concept, but how do we ensure that humans understand what it means to be living in harmony with the environment? Do they understand that extinction affects us all? Are we in the law dividing rather than conquering? And Peter was asking me specifically around, and it's not just him, many people have said to me that they don't always understand when we publish things for comment. What was our inner thinking? It's not apparent when you see a notice in a gazette changing EIA regulations or whatever it may be, NEMA. How do we facilitate and promote sustainable and responsible development? Are we achieving that? And of course, I don't go on to site every day, et cetera, but I draft law and I try to give effect to the environmental right. And maybe that is also assessment of another nature. I may not be physically in the field and I may not be a scientist, but maybe we need to assess why are we concerned about environmental impact assessments? What are the obvious linkages, and are the linkages obvious when we put out the law for you to comment on or to implement or to understand? And how do we convert that into effective and rational law, EIA, environmental assessment, environmental authorizations and policies, or do we actually achieve the converse? So we struggle, okay? It's no use pretending that we're perfect and we get everything right, because then we wouldn't have been worried about the environment, we wouldn't have been worried about the law. But sustainability and environmental law, the core of that, in my personal opinion, is that extinction affects everyone. But not everybody understands that. People call environmentalists tree huggers, et cetera, but unless we understand that, I mean, sustainable cities, clean energy, access to water, these are all things that are mentioned in the SDGs. It's all related to sustainable development, but how do we achieve that? We ask for EIAs, but EIAs have such a bad name outside, where people do not make the link between how the EIA is going to ensure that we keep to our environmental rights, sustainability, and ensure that we protect ourselves and future generations. Now, very interestingly, I've spoke about the 1997 ECA provision. Sorry, that's my dog getting all excited. I hope you can't hear him because I've got my earphones on. But of course, when we got Minister Creasy, we also got the Forestry and Fisheries portfolio. And almost immediately, we were confronted with law that we didn't know, but we were again confronted with human settlements versus the environment. And how do we protect and balance and compromise? And it was last year where we actually needed to very quickly become experts in specific portions of the National Forest Act, where there were invasions in the Eastern Cape, the Greydal and the Fort Grey areas. And you won't be able to read the slide, but that's just a depiction of the area. And the notice on the right-hand side was, I think, precisely September last year, where we used the law in order to protect. We relied on Section 7 and 17 of the National Forest Act. Like I said, we had to get help from the experts in the forestry section. They are a great bunch of people. And we tried to ensure that the law could be of assistance in protecting, and the portion in quotes there is what the minister issued in her statement. We use the law in order to protect an integrated functioning ecosystem. And it's not just about an integrated functioning ecosystem, it's in order to give the environmental and the eco assets to ensure that the area there could still be accommodating the human environment and whatever development is occurring in the area. Powerful, I think so. I mean, this was last year. I've spoken about the ECA in 97. But 25 years ago, of course, we also had, or 24, thereabouts, we had the Environmental Conservation Act, Minister Paulo Jordan, who issued the first set of EIA regulations under the ECA, the list of activities. And if you look at those things, it's fairly straightforward. But of course, there were a lot of loopholes and a lot of learning curves in how we listed these things, how we identified them, what process we were looking at, and a lot of leeway in between. But it was a tremendous effort. It was the first set of EIA regulations requiring legally for you to comply with these authorizations at the time, and ROD, before you could develop certain things. 15 years ago, the NEMA EIA regime basically came into effect. You would have seen that the ECA one is a no frills, no fuss approach. In 2006, of course, we had the NEMA approach, the whole CONEP process that led to NEMA. We're still sitting with some of the ECA provisions, and my team is trying to also find a solution to ensure that all the ECA provisions find its way either into NEMA or into some of the specific environmental management acts before we completely repeal that act and all its provisions and subordinate legislation. But then, of course, you would have also seen that there are differences between approaches in the ECA and the NEMA regimes. We got quite pedantic and focused on thresholds and process. And in June 2021, this year, there were again amendments published. But I think there's perhaps an attempt to get back to the holistic approach of the ECA, taking all the lessons learned in the last 25 and 15 years. In order to get back to a mining, well, in that case, we were looking at mining specifically, mining development, mining application. How do we consider impacts holistically? How do we list holistically instead of saying, all right, in this area between these thresholds, you are listed, but nothing else. And I think we need to maybe consider going back to an approach like that. We know that EIAs have its limitations. It's difficult to look at cumulative impacts when you're only looking at a specific development application. And, you know, we also know that the impacts remain long after the development has occurred. And are we doing justice to, or are we failing to give effect to the environmental right? We've become so fixated on procedure that those are where the challenges are instead of the substance. And just last week, I had a discussion, quite a lengthy discussion, and I had such sympathy with this person because she was speaking about subdivision, and that subdivision is no longer listed, but the impacts of subdivision are not well understood. The environmental authorities and the local authorities struggle to understand why they have a mandate when it's not requiring an EIA. And it's coming back to this whole issue around long-term impacts, even though a subdivision in itself is a paper or admin exercise. It's potentially dramatic in the sense that you put up boundaries, you prevent species from moving, etc., etc., and eventually the subdivision in itself has far-reaching effects. So there's a lot of frustrations out there and quite well understood from my side as well. We've had this one environmental system story where every day I felt like this, but of course we couldn't quite give effect to that ourselves. But this is sometimes, I think, the kind of conflict that we sit with. And when we don't understand what we're all trying to achieve, it sometimes leads to this. It's all good and well if there's conflict and difference of opinion, but if people don't understand where you're coming from and what you're trying to achieve, and that is for the greater good, and it's not really just about hugging a tree or being defensive about a butterfly, it is about giving effect to the environmental right, then maybe we can start winning some of these aspects about convincing people why environmental assessment and the environmental right is important. I've always found that, especially in the last couple of years in this country, we've had a very healthy judicial system. People are not afraid of challenging decisions that are not rational. This one is just a picture from the Government Gazette of May 2021, where the Water Affairs Department has also provided some fracking notices for comment, but we are very hard trying to provide a partnership with water and sanitation, where we can put all of the fracking requirements into one single piece of regulation or notice, so that there isn't this fragmentation and that we do give effect to the environmental impacts of this kind of development, which we know of is very controversial. And in the Sunday Times of 4 July 2019, of course, the court ruled that the Minister of Mineral Resources didn't have the power to make those regulations and are environmental in nature, and therefore we are now tasked with doing these regulations with water and sanitation. But all because of the court system and people saying, but this doesn't make sense. And those of you who have followed the cases would know that there were 2 cases ruled upon, and then different rulings in different courts resulted in this ruling where the environmental mandate was confirmed. Climate change, the Tabametsi case is just one of many, and that quote is just from the case where the High Court was asked to determine whether under NEMA relevant considerations for environmental review of plans for a new coal-fired power, the Tabametsi power project case. And in this case, it was also, I was asked specifically to talk about climate change. I think even between August and September, between the 2 presentations, we've now heard that the Cabinet Committee had endorsed the climate change bill, and that would also be going out for comments soon. Also, I think different views about whether it should be a separate act, etc., but at least it's being put on the agenda. This one was from the CER website, and this guideline that we were trying to put out, well, it went out for comment around EIAs and climate change assessment, which is, of course, the Tabametsi case has resulted in this. This one has now closed for comment, and the department is working on finalizing it. So probably keeping your eyes open towards probably the end of this year or early next year. But the guideline was essential because of the court ruling, and also because
Amanda, 5 minutes.
Sure, almost done. This guideline may be far from perfect. We don't necessarily we ignore sometimes the elephant in the room, growing populations. How are we going to ensure sustainable development if there's a greater demand on the environment to sustain that? I've spoken about the climate change bill and growing recognition, as I said, of at least some world leaders, but we all know that some people just refuse to understand some logic and the facts that stare them in the face. And it's not always about science, it's about feeling it in your own home, in your own day-to-day activities. So I think in conclusion, 25 years and counting, I don't think we've done too badly, but the challenges are many and the progress is slow. The threats to the environment threaten our human existence, and they remain, and they will probably grow in severity. And we must therefore pursue trying to give effect to the environmental right, sustainable development. The wins are sometimes very small and the loss is huge, but we do try to use the law to give effect to that environmental right. And we shouldn't be focused and fixated on protecting butterflies in areas because people don't draw the linkages between why it is important. And of course, we are under threat. We need to ensure that we give that picture and that message across and draw the linkages. And we shouldn't be denying the obvious. I just wanted to make sure that my assistance has paid off. I'm sharing the sound and I'm saying, please don't deny the obvious. I'm hoping that this works. We tested it. This is just a typical example, probably 60 seconds of denying the obvious.
Thanks very much, Amanda. We're just keeping track of our time, and I think we can move straight to Willemien's presentation.
Tendai, sorry, there's a video showing still.
Oh.
Thank you very much.
Thanks, Amanda. Sorry for cutting your presentation short there. Very informative, and I think in keeping with time, we'll move on to Willemien's presentation. Willemien, over to you if you're ready.
I'm just trying to share properly. Thank you. I think mine more or less link up with what many people have said before. I presented this paper also at the ISN Academy in July last year. And it deals with a comparative study that I've done between all the environmental, not all, many of the environmental framework laws in different African countries. By now, most African countries have adopted environmental framework laws subsequent to towards the late 1990s and also recently. South Africa and Kenya were of the first countries that adopted environmental framework laws, and the others followed suit in the 2000s. Subsequently, environmental framework laws were amended. We see new versions of environmental law that comes to the fore, and the most recent one is from Uganda in 2019. The question is whether the older environmental framework laws address the new environmental challenges and if there's a need to amend these challenges. So the aim of the paper is to benchmark the South African environmental framework legislation against those of other countries and to distill best practices for future implementation. Now, some of my own previous research, and I'm becoming not the mother, but the grandmother, perhaps in environmental law. In 2001, Johan and I published an article on the framework law, a theory on it. And it was based on the work of the late Professor Ukidi, Nolan, and Iqbal. In Saltrock a few years ago, I asked the question whether these environmental framework laws include climate change challenges, based on also on the work that I realized later was published on Yazekova and Bruch, and subsequently Andrew Gilder and Olivia Rumble also published an article dealing with climate change laws in Africa. During an ISN Academy conference in Scotland, we asked whether the adoption of new technology should also be considered while you are busy with either environmental impact assessment or even before that. Now we know that all the countries in Africa have different administrative legacies due to colonization, but there are always new challenges come to the fore. And Wiener wrote a nice article already in 2001 where he explained that when there are new challenges that has not been dealt with before, countries tend to borrow legislation from other countries. And sometimes in the case of environmental law, international organizations or other countries influence the laws of countries in the developing world. But we also realize that you cannot just transplant laws from other countries into our own legal systems. There should be careful consideration in terms of its applicability, existing legal system and hierarchy, the administrative capacity, etc. With regard to African countries, it must just also be said that it's not always to determine what is the most recent updated version of the legislation, work with databases, and of course, language difficulties also prevent me from studying, for example, Portuguese speaking countries. I focus in this only on the English speaking countries. So in this paper, I will refer to the environmental law framework structure measured against the African framework laws, and then the new emerging themes that comes out in these laws. So this slide you have seen before, where we defined the environmental framework law. We say it aims to define overarching or generic principles in which you will embed your sector-specific legislation, and also to enhance cooperative environmental governments amongst fragmented line ministries. So the aims of environmental framework law, if we look at the African environmental framework laws, we see that most of these laws include principles rather than policy. Sometimes the sector-specific issues are included in the environmental framework law, while countries such as us have an environmental framework law, and then we have sector-specific legislation. Most of these legislation have some sort of structure to ensure cooperative governance amongst fragmented line ministries. We see that not all the legislation is flexible. There were many amendments through the years. There are few countries who did not amend their legislation. So, for example, Mozambique is still the same as it was before. But we also see the older framework laws do not necessarily address the emerging issues. With regard to public participation, we see that all of the laws include something on public participation, sometimes only in relation to environmental impact assessment. Some have specific sections, others just mention it, but the scope and the nature of public participation differ amongst the countries. We also see definitely inclusion of soil-based instruments, for example, locus standi, access to environmental information, and some of the countries will include the environmental right if it was not in their constitutions. And then most of them also refer to the need of environmental education, a theme that also came out during this conference. With regard to the mix of environmental instruments, if I can use the graphic that's in Fugul Arabi, most of them relate to the duty of care. Most of them make provisions for norms and standards. They refer to environmental impact assessment in some way or another, and they also include other environmental management tools. The conflict between different organs of state with regard to the regulation of the environment is not well described in this legislation, and Amanda also referred to that aspect. There's also not a clear distinction of what is the hierarchy between environmental framework law and national legislation, but a few countries did that, and Zambia and Kenya and Uganda specifically states that the environmental framework law has a higher status than the other laws in the country, and that the environmental aspects have to be dealt with. Many countries have environmental courts or tribunals, but as we know, also in our country, it's not everywhere. So there are two specific environmental framework laws. There's a general and overarching framework law, as I've explained, and then those that include both aspects, the framework and sector-specific issues in the legislation. So why would we say is there a need for change? What's the current debate? If you look at debates all over the world, also in Australia, we see there's a call for simplification, a quicker road to development, shorter timeframes, less bureaucratic measures. There's a move towards the ecosystem approach rather than an anthropocentric approach. We see that some legislation refer to environmental and social impact assessment and does not necessarily deal with the economic benefits of a project. And it was also something that came up during our discussion. And then in South Africa, we have this new infrastructure development plan coming up, and definitely as a clear focus on development in the country and also post-COVID recovery. So the emphasis is more now, especially post-COVID, on economic growth and job creation, and that's not only in South Africa, it's all over the world. So some other people argue that there should be integration of issues, again, that we should follow ecosystem approach rather than a silo approach, that we will look holistically at everything, and Amanda also addressed that. Uganda recently included the rights of nature in the environmental framework law, the protection of that, and the locus standi to enforce that right on behalf of the nature. They also include the possibility for payment for ecosystem services, which I didn't see in the other legislation. They definitely refer to climate change issues and the impacts of climate change on ecosystems. There's also the need to think about the adoption of new technology, especially now with the fourth industrial revolution. We tend to celebrate new technology, but not always thinking about the long-term effects of this technology. It's something that we don't address in our legislation very clearly, except in the medical sciences. Then there's also a need in the holistic approach to deal not only with environmental issues, but we see that some of the countries deal with energy security, efficiency, and renewable energy. In Tanzania, Zambia, and Uganda, there's a clear emphasis also on the cultural aspects. And that's also a theme that comes through this conference from Advocate Tebeka's a speech from the beginning. Now, prior and informed consent was also discussed in this conference, and we see it in the court decisions. It was now confirmed. The only country that actually referred to that is Malawi in their 2017 framework law, but it's not exactly the same as it's interpreted by our courts or in the literature. And then there's, of course, corporate social responsibility, environmental social governance, etc., new themes that comes to the fore with regard to finances. There's also a huge emphasis on that we should respond to social issues, also now in environmental framework laws such as COVID, food security, water security, energy security, HIV/AIDS, etc. And Malawi in its 2017 Act take these principles actually further. And when you read it, you will see they refer to gender, health, human rights, disability, etc. Uganda also specifically mentioned human rights and the protection of human rights when we deal with environmental managers. Uganda foresees a mix of instruments. Malawi is the only act that sort of passingly referred to a voluntary environmental management, but it's not taken further. Tanzania, Zambia, and Kenya place a huge emphasis on community involvement on the village level or traditional leader level, also with protection of the environment. And Uganda, for example, devolved it down also to an urban and a district level. Uganda also now referred to the green economy and the circular economy. That's new themes that's coming to the fore. And green recovery, environmental health issues, preparedness for disasters and emergencies also now need to be addressed. Malawi, in its 2017 legislation, refers to economic instruments and incentives, but we also need now a place for green financing, sustainability financing. We see more and more talk of green bonds, etc., sustainability bonds that comes to the fore. Most legislation also provides for an environmental fund, something that was advocated by several writers and groups and NGOs before, but is still lacking in South Africa. So in conclusion, environmental framework law in Africa is quite advanced. It may be the involvement of UNEP or other organizations, but we see that the new legislation is perhaps more able to respond to the newer challenges. If we measure our framework law against the newer African environmental laws, we see that we must think, how will we include new emerging issues? Should we only wait for the courts to do so? Should we be preemptive? There is a continued or more emphasis now, especially post-COVID, on environmental health and social issues. We should deal with prior and informed consent also in the legislation. We should think of environmental tribunal and environmental fund, although we know it's complex with our financial legislation. We should think, how should we deal with the adoption of new technology? And of course, climate change, the green economy, circular economy, and etc. And then also, as Amanda pointed out, how are we going to deal with a holistic or integrated or ecosystem approach when we deal with environmental assessments? And then we can move to the discussion. Thank you.
Thank you very much, Amanda and Willemien. Very insightful contributions. And I think it's safe to say that significant progress has been made with regards giving effect to environmental rights, not only domestically, but in the rest of Africa, from the sounds of things. But I think it's safe to say that South Africa is a front runner in this respect, in view of the robust environmental law framework that we've developed. And I think we have set the pace for the rest of Africa or the other continents to follow suit. With that said, I think there is definitely room for improvement. And I think with that, we can move to the questions. There are quite a few questions in the comments section. So I think it might be best to deal with those aspects first, if you don't mind. I see there's a comment from Vanessa, who's commented on the importance of the EIA process and I think the public participation. And she asked us a follow-up question in that, is there a mechanism to ensure that where new information arises after an environmental authorization has been granted, is there a way to include this information and ensure that any associated impacts are catered for? Amanda, I think you are best suited to take that question on.
Thank you, Tendai. I think Vanessa asked that question. She started off by saying there's a real problem if the cumulative effect aspect in the EIA is not covered quickly enough. I think my point around cumulative impact was rather that an EIA is looking at a development-specific issue, and it's very difficult for a project-specific assessment to look at cumulative impacts from other developments. But what she was also concerned about, and I think Karen also looked at that, is post-construction impacts. And I think there were issues around focusing the impacts that could be assessed in the EIA process and the environmental authorization process to be quite limited. And I think there is still a little bit of people are not feeling happy with that, because the EIA, there's a balance to be struck, because you need to understand that an EIA is looking at one development, but there's also the environment, the receiving environment, and the cumulative impacts. But to what extent can an EIA achieve that? And I think strategically, there is a lot of developments in the strategic assessment field where we could probably take our cue from looking a bit more broadly to developments in a bigger area, and to see to what extent impacts are associated with developments and how it reacts into certain receiving environments. So I think to expect an EIA to deal with all cumulative impacts is going to be a big ask, and I don't think it's fair. It can do so through public participation, INAP engagement, but we also know the flaws in the consultation process. of course, when you've issued an environmental authorization, and I sometimes am a little bit disconcerted when I look at some of the EAs that are issued, and not just EAs, I mean other decisions in the environmental field as well. They don't go far enough. It's like it doesn't deal with the critical issues. It doesn't necessarily have the ability to deal with post-construction issues or impacts that come after the assessment has been done and because of new information being brought to the fore. But then you need to also fall back on some of the principles that Willemien was speaking about now, the duty of care, what that means. And you know, all of this is lovely, but if people don't understand why it's important to do this, they will always find loopholes. And it's not just in the environmental field. They will find loopholes in tax law, etc., because they're really not interested in always achieving what we are set to achieve by giving effect to the environmental right. I think apart from the duty of care, the conditions, we were just looking now at a biodiversity offset guideline. And you know, the timeframes that we're speaking about in these processes are such that you cannot fit everything in there. You cannot have rational decisions or rational processes that deal with everything. So at some point, we need to start thinking about lifting these things up a level and doing things a little bit more strategically so that people understand the bigger picture and then fit into that. The subdivision thing that I think I touched on in my presentation is a typical case in point. People don't understand why it's not a listed activity, but the listed activity, the moment you get into an EIA process, I guess you're already sort of saying this development is okay. So what do we do before you get to that point to ensure that the development is in fact compatible to the area and it won't have long-term impacts that you cannot deal with in an EA because you don't necessarily know of all these things. You can't put all of those conditions in the EA.
Thanks very much, Amanda. Just moving on to the next comment from Melanie, and this relates to the fracking regulations, and she's curious to see that the regulatory approach shift from a detailed regulations to a mere listing in the EIA regulations. And the question is such an approach under the auspices of the current authority not now weaker than what was originally envisaged? I think, Amanda, you might be better placed to also speak to this one.
Sure. What I said about the fracking regulations is we're not necessarily doing a listing for fracking. And I think Anél also asked about cooperative governance, and I coined this partnerships in the previous presentation that I did. For fracking, we are obviously taking our cue from what are the environmental aspects in and the environmental impacts of hydraulic fracturing, but we're also looking at the water aspect of it, and we're trying to do a holistic regulation under NEMA, not a listing per se. There is obviously a listing aspect to it as well, but we're trying to do an aligned and combined regulation that deals with the environmental aspects, which should be inclusive of the water aspects in a regulation. And you would have seen that picture that I put on from Water and Sanitation publishing their draft regulations for comment. And there's been a lot of negotiation happening during this year where we tried to convince them, and it seems like we finally succeeded, to say to them that we could incorporate all of the water aspects and the requirements that they had in that specific notice for comment into a NEMA set of requirements, and then dealing obviously with, and it's going to be quite a complex thing to deal with, to see to what extent we can then keep to the different mandates, but without losing any of the water aspects in it. So it's not just about listing it for specific mining purposes, but in this case, the fracking regulations will be an all-inclusive set of regulations that would deal with all of the potential impacts, bring over the stuff that was in the DMR notices, and try to deal with these in a consolidated fashion so that we deal with all of the issues that are relevant without duplicating and splitting the regulatory requirement.
Thanks, Barry. Could I follow up quickly? Is the intention then that they'll if I understand you correctly, there'll be a much more detailed set of regulations forthcoming through water.
The detailed set of regulations that the comment gazette that you've seen on my slides were the water aspects that Water and Sanitation published. Even before they published that, we've had engagements with them to ensure that these things are included in the other aspects that we are putting out for under NEMA for fracking. So eventually, we would probably put out a regulation under NEMA that would be inclusive of the water aspects and not the other way around.
I see. Thank you.
Thanks, Amanda. Perhaps in the interest of time, and to allow greater inclusion, we'll open up the platform for verbal questions before we turn back to address a few of the comments in the chat. Sandy, I think you had a question for Amanda.
Thanks, Tendai, and thank you so much, both of you, for the fascinating presentations. Mine's a very broad question. I've lived through 4 EIA regimes. I've taught through 4 EIA regimes, and I'm struck by the increasing complexity, and I find it increasingly more difficult to fit all the pieces together, let alone explain them to a group of well-resourced, well-educated master students on an annual basis. The focus of much of our attention is on how effective is the law in giving effect to the environmental rights, but that's a right held by all, not just the well-resourced. It's held by the less well-resourced too. And I often feel that a crucial question which may be forgotten or somewhat forgotten is the aspect of how user-friendly or accessible is the law to all, not just to the academics, the lawyers, the developers, the authorities, and the well-resourced NGOs. And my broad question is, how do we draft law which ensures that it is accessible, that it is usable, and that it is understandable to all? And specifically, Amanda, I'm interested in how that type of issue is factored into the discussions when this legislation is drafted in the corridors of government. Thank you.
Tendai, do you want me to respond to that, or do you want to take 1 or 2 more questions?
I think we can take 1 more question. Karen, I think you have your hand up.
Thanks, Tendai, and thanks, Willemien and Amanda, for excellent presentation. I want to raise two, in my mind, critical issues. And the one is that I'm asked to, I'm not working for government, but as an independent person, I'm asked to review a lot of EIAs or when there's potential application for appeal and so on. And my apologies to the consultants in the room, they are of a pathetic standard. Now, coming from a scientific background, the basis of any scientific research is peer review. And I cannot understand why there's not a compulsory peer review process in the EIA mechanism. The EPS system was supposed to be able to address that, but it's simply not effective. And EIAs are done in isolation, submitted to often unexperienced government officials for review, and they do not have the ability to really properly review that document. And it is, your computer can say Intel inside or in once. If it's idiot outside to compile the report, you're going to get a bad EIA out of it. And I saw somebody raise the issue of why is the conditions in the EIA so bad? It's because the reports that was used for them to be based on were so bad. And so if we implement a compulsory peer review mechanism, we'll deal with a lot of those bad EIAs, bad environmental authorization issues. And the second one is more for a future question, a future issue. Amanda, you mentioned in other legislative regimes and other governance aspects, there are similar struggles. And in my research that I've now done on a number of cases, we see that not only in environmental law, but in other legislative components, there is a move away from rule-based approaches to risk-based approaches. And I think in the different levels of listing notices, it's kind of an attempt to do that, to say, well, if this is the harmful activity you pose, irrespective of the environment, you'll do an EIA. Or if this is not like such a harmful activity, but a sensitive environment, this is then a need to do a basic assessment or an EIA. But we still stick with certain rule-based things like 25 meters, 50 meters, 100 or 800 square feet, or whatever the case may be. And should we not implement a better screening system? And instead of having the screening system in listed activities, have everybody pass through a screening system that's really truly risk-based. And then you'll, number one, have less EIAs, but you'll have EIAs that count in sensitive areas, and you can better deal with cumulative impacts.
Thanks, everyone. Amanda, you're free to address those questions.
All right, let me try and be quick around them because I think there are many other questions that people want to pose as well. On the issue around different EIA regimes, I think that was precisely what I was trying to get to. And in my presentation around, we've seen 25 years, but what did it mean? We started off with a rather broad focus on developments, and then we got fixated with thresholds and timeframes. And I mean, that was all of those were practical issues that came as a result of criticism against EIA, needing to ensure swift development, swift processes, etc., etc. So sometimes when you draft the law, it's not really within my own capability to advance arguments, but be that as it may, I think what I did try to touch on was the inner thinking, and I think we do way too little of that. And I agree with the concept around how do we make this accessible to people. And I'm very grateful to people like Janice Tooley, who has taken it upon her to make sure that EIAs that are consulted on a project level in certain areas, that some of these things are made accessible to people, understandable to people. There's a lot of, well, a couple of engagements and projects in the department where we try to ensure that there is access. But of course, the law is quite a complex piece of thing to go and explain to people. I just think that we should get off our high horses in government and accept that we struggle, that we can't do it all, that we need partnerships, and we should trust people outside to help us with that. To not be defensive when people tell us that there are problems, that they perceive it in a certain way, even though it wasn't intended to be put forward in a certain fashion, and that the regulated community and the environment suffer as a result. So for me, I think I'm not sure that perception and view is always shared. And when I move on to Karen's points, I think I would rather not express too much in response to your issues, Karen, because I think I agree with a lot of what you were saying, but you must also remember that we sit in a scenario, in a factual circumstance in a country where peer review, I'm not sure how that will work, how that would pan out if we were to do that, because there would always be questions and criticism against any system that we put forward. The compulsory peer review is a good concept, but I'm not sure in certain countries where they are very, very well at organizing themselves, and there's not this level of mistrust between developers and environmentalists and government, it works quite well. But we don't have the financial resources, etc., to do that kind of thing at the moment. And I'm not sure that we would ever be there. So you need to find other ways, but we need to also understand what is the real problem. And I think unless you identify the problem correctly, you can't, your solutions are always going to be not so well adjusted because you don't understand the problem necessarily. I think there is a move back towards looking at developments more holistically, not looking at the 25-meter threshold, etc., etc. And I think what we've been forced to do is to do the screening in the listing notices, but there is, of course, a lot of shortcomings and gaps in that approach. And we are trying to see to what extent one can maybe move back to a more holistic approach, a more realistic and rational approach from a real environmental perspective or impact perspective on the ground, receiving environment kind of thing. And there's been a lot of talk around reconsidering the way in which you're listing activities and providing the initial trigger for these activities. And I think especially the Western Cape has been thinking about putting a list out there or development types and then saying, depending on certain criteria, precisely what you were talking about, a screening, a pre-screening kind of system. How much buy-in there's going to be in government, outside of government, and how that's going to pan out is probably going to take years. But I think there's a general perception that something like that is needed.
Great. Thank you, Amanda. I think we can focus back on the comments and questions in the chat. Willemien has kindly offered to address any questions directed to her in the chat, so please look out for any responses to your questions there. So I think we'll focus on the questions and comments raised to Amanda, and Melissa has a question, and she asks, do fragmented and unsystematic changes to our environmental laws, particularly the NEMA listed activities, not hinder giving effect to the Section 24 environmental right? As a follow-up to that, she asks, why are the continuous changes to the NEMA listing notices not consolidated instead of being made individually? Amanda, if you don't mind, you can address those two questions for now.
Very difficult ones, because if we leave all of this for once, we will never publish anything. You don't necessarily sit in all of these negotiations, just internal, not just in our department, but amongst authorities around what goes in and what goes out, and the fights that we have around these issues. Of course, it would be better to have a more holistic approach. I agree that these one-by-one amendments are not helpful, and I think there was already speak and talk around doing more than just the June focused amendments on the mining stuff. If others had their way, there would have been a plethora of things that would probably not have been published for implementation, and maybe not for comment yet, because unless you focus on some of these aspects one by one, you can't deal with it. And you would always have to know what your bottom line is before you go into negotiations, which makes it very difficult, because we're sitting with a multitude of authorities that implement these that are far better equipped to tell us what is happening on the ground. But also, I mean, I don't necessarily go on site. I don't necessarily deal with people on the ground, but it's very difficult, and you do confuse people when you amend every time. But I think what there is a bigger push towards moving back, as I said, to a more, I don't want to commit to anything, but I think there's a general perception and appreciation that the little bits and pieces that are listed at the moment doesn't necessarily achieve what we want. We've seen climate change, we've seen changes generally occurring over the last couple of years. We've seen the level of strategic and land use planning, municipal planning aspects that are actually the triggers that result in many of the listings. But we need to ask ourselves, why are we listing some of these things? Because they are potentially problematic because of something else that has informed it. So maybe if we could go back, and I've showed the listings in the ECA regime, and I've showed the listings, and we talked about the pedantic thresholds and not necessarily looking at the receiving environment, etc., etc. We really need to reconsider what we're doing here. See to what extent the listing notice approach is the correct one. Have a listing notice, but maybe for a different purpose, to see to what extent you could see or identify development types that are problematic because of whatever environmental risks they pose or impacts they have, and then see to what extent one could potentially bring them, depending on receiving environment, size, etc., maybe consider a single list, and then depending on the screening criteria, determine whether an assessment is required, whether you need to do a full scoping and EIA, whether you could have a norms and standards hands-off kind of approach and allow it. I think we need to go back there, but it was easy to move from the ECA regime, where it was a holistic approach, to a more detailed approach. It's going to be much more difficult to move back to that kind of no frills, no fuss listing, and then giving discretion to determine what do you require under which circumstances.
Thanks very much for that, Amanda. We're just cognizant of the time, and unfortunately, we will not be able to address or to get to all of the comments and questions in the chat. What we will do is we will keep track of these, we'll catalog these questions and potentially arrange future information sharing sessions where these issues can be ventilated more. And with that, we thank you for taking time to join this session, and many thanks to both our speakers, Amanda and Willemien. We are grateful for the contribution you've made to both the development of environmental law and giving right to the environmental right. And we look forward to having you at future ELA annual conferences. Thank you very much, everyone. We hope you enjoy the remainder of their annual conference and have a lovely weekend.